This program is brought to you by Emory University.
Good evening. I'm Robert Shapiro, Dean of Emory Law School, and it is my great pleasure to welcome you to this very special evening. Thank you for beginning your Martin Luther King Jr. weekend activities here at Emory Law School. First, I'd like to offer a warm welcome to our distinguished speaker, SHERRILYN IFILL. We appreciate your taking the time out of your busy schedule to be with us this evening. I'd also like to thank my colleague, Professor Dorothy Brown, who had the vision for tonight's gathering. I'm very grateful to Professor Brown for all she did to make this event a reality and for all of the many ways in which she contributes to this community. At Emory Law, we seek to advance the rule of law through the students we educate, the ideas we create, and the service we perform. Diversity is an essential component of accomplishing this mission. The inclusion of people from diverse backgrounds with diverse perspectives is a critical element of our intellectual community, of the learning in our classrooms, of the insights of our scholarship, of the value of our service. Emory has long been a leader in promoting diversity. In 1962, Dean Ben Johnson, class of 1940, and chair of the Board of Trustees Henry Bowden, Emory Law School class of 1934, brought the lawsuit that allowed the integration of private colleges and universities in Georgia. That litigation transformed higher education in Georgia. It was part of a movement that helped to transform the legal profession. It was part of a movement that helped to transform the world. However, diversity must be an ongoing commitment. We honor the achievement of Johnson and Bowden not merely by historical reflection, but by ongoing action each and every day to make our community diverse and inclusive. Johnson, Bowden, and others did not labor so hard to make diversity merely a theoretical possibility. It must be a lived reality. Our task is to continue that tradition, to create the reality of diversity in our classrooms, our courtrooms, our boardrooms. That is how we honor our past accomplishments. That's how we ensure our future excellence. That is how we prepare our students for leadership in the global environment of the 21st century. Now, last year, we announced an anonymous $1.5 million gift toward a John Lewis Chair in Civil Rights and Social Justice. Through this chair, we are honored to recognize Congressman Lewis's historic achievements, and we seek to inspire the Emory community with our commitment to excellence through diversity. The law school is seeking to raise additional matching funds of another $500,000 to fund this chair fully. This generous gift will enable us to conduct a nationwide search to identify a distinguished scholar with a demonstrated desire to promote the rule of law through the study of civil rights. If you have an interest in contributing to this cause, a member of our development team, Robert Jackson, would be happy to speak with you after the lecture. I would be as well. Well, I want to thank you very much for being here tonight, and now I'd like to invite Dorothy Brown, Senior Advisor to the Provost and Professor of Law, to introduce our speaker this evening. Professor Brown.
Thanks, Dean Shapiro, and welcome. I have the privilege of introducing SHERRILYN IFILL this evening. SHERRILYN IFILL is a nationally recognized advocate for civil rights, voting rights, and judicial diversity. She is equally likely to be presenting testimony on Capitol Hill or being interviewed on the Sunday morning talk shows. In 2012, SHERRILYN IFILL became the 7th president and Director-Counsel of the NAACP Legal Defense and Education Fund, Incorporated. This was not her first stint at LDF. She served as Assistant Counsel for the Legal Defense Fund from 1988 to 1993. Where she litigated voting rights cases. Among her many successes is the case of Houston Lawyers Association versus Attorney General of Texas, in which the Supreme Court held that judicial elections are covered by the provisions of Section 2 of the Voting Rights Act. She then left LDF to join the faculty at the University of Maryland Francis King Carey School of Law. I am most familiar with SHERRILYN's scholarship concerning the judiciary. SHERRILYN argues that all judges are affected by their own background and life experiences, and that diversity on the bench is key to creating a court that can wisely interpret the law. The notion that white male judges are neutral and impartial umpires, while women and people of color are viewed as biased, is fundamentally flawed. When I was working on the third edition of my critical race theory casebook, I decided to add a chapter on racial bias in the judiciary. The first scholar whose work I looked for was SHERRILYN's. I found the perfect piece and then realized, crap, SHERRILYN's at LDF now doing her Wonder Woman thing. She'll never find time to give me the copyright permission. But anyone who knows me knows a 99% chance of failure won't stop me. So I sent her an email, and to my delight, received her permission. She actually answers her emails. As SHERRILYN has observed elsewhere, America is still relatively new at this thing called equality. We are working our way through perfecting this democracy. SHERRILYN and LDF have been at the forefront of helping America perfect democracy. SHERRILYN is a scholar activist in the truest sense of the term. Her critically acclaimed book on the courthouse lawn, Confronting the Legacy of Lynching in the 21st Century, explores the lingering effects of lynching. She is currently working on a book about race in the Supreme Court confirmation process. SHERRILYN is also a selfless human being who cares greatly about and serves as a mentor to the next generation of civil rights lawyers. She also has extraordinarily good taste, as she seems to be as obsessed with the Broadway play Hamilton as I am, something any casual observer of her Twitter feed will discover. After SHERRILYN speaks, she will open it up for questions, and you should go to one of the two microphones here. I will return to the stage to signal when we have time for one more question. Then we can all move to the outer room for the reception. I present to you my friend, SHERRILYN Ifill.
Thank you. Good evening. So thank you, Dean Shapiro, and thank you, Professor Brown, Dorothy, for that lovely, lovely introduction. And thanks to all of you for coming tonight. I have long been an admirer of Professor Brown and of her scholarship, and that was part of my enticement in agreeing to come tonight. But I had other reasons as well. I always feel honored to be asked to give a Martin Luther King Day talk in Atlanta. So that's one of the attractions. The other is that I had an opportunity and have an opportunity to see one of LDF's senior board members, Billy Suber Aaron, who came to be with me this evening, which I appreciate, and one of my absolutely dearest friends, college classmates, Lisa Wheeler and her family, who are here with us as well. So just happy to be with you tonight. So this is a difficult and very challenging time for those in my trade, those of us who do the work of civil rights. And I want to talk a little bit tonight about what I think is the moment that we're in, what I think that moment requires of us, and what I think we can learn from some of the work that is the foundation of the work that I now do. And while many of you may not be lawyers or law students, my remarks are largely focused towards those who have taken the oath or who plan to take the oath to become lawyers, because I do believe that we are especially called upon in this moment to play an important role in strengthening this democracy. And I, of course, miss the engagement that I had with law students every day when I was teaching at the University of Maryland Law School. I'm technically still on leave from the faculty. And one of the things that I loved about teaching was the opportunity to feel as though I was developing the next generation of civil rights lawyers, to encourage every student, whether they thought they wanted to be a civil rights lawyer or not, to think broadly and deeply and without fear about the implications of the legal principles that undergird our system of justice and legal practices and policies and assumptions that shape the lives of ordinary people, and especially the lives of those who live at the margins. I have always adhered to the view that lawyers are the stewards of one of the most important elements of a healthy democracy, and that is the rule of law. And to be proper stewards requires us to look beyond the comfortable, the obvious, the received wisdom. It requires us to be courageous, to leave our comfort zone, to confront the contradictions between our principles and our practices, to examine our democracy from the vantage point of the marginalized, from the perspective of those who are not heard, through the eyes of the least of these. You cannot really tell if your democracy is strong or if it has integrity by looking at how well it serves the privileged, the intelligent, the well-resourced, the beloved. The strength and integrity of our democracy can only be measured by examining how it serves the poor, the disenfranchised, the voiceless, the elderly, minorities, refugees, the uneducated. And that's why I've said in the past that to be a civil rights lawyer is to be involved in democracy maintenance work. And I've also said that in this time in which we live, when judged by the measures I just described, we must face that our democracy is in a moment of some crisis. The crisis is one of laws and also of men and women. And so I'd like to talk a little bit about what that crisis looks like as a matter of law, and then a little bit of what I think are the issues that, as men and women, we have to face as well. So, crisis of laws. Perfect example, I was on the job at LDF for 6 months when the Supreme Court decided the Shelby County, Alabama versus Holder case, a case that we litigated from Alabama, in which the Supreme Court essentially struck down or hollowed out a key portion of the Voting Rights Act. It struck down Section 4, which was a provision that allowed for the review of voting changes among various jurisdictions throughout the country through Section 5 of the Act. And this provision was regarded as the heart and soul of the Voting Rights Act because it required that any voting change that was sought in these jurisdictions would have to be pre-cleared by a federal authority before they could be enacted. And this provision had existed since the beginning of the Voting Rights Act, and it was enacted for a particular reason. Congress said in the legislative history in 1965 that they wanted to get at not only what was currently taking place in terms of voter suppression and voting discrimination, but they wanted to get at any ingenious methods that might be used in the future. And so they created the pre-clearance process. And in 2006, when the Voting Rights Act was reauthorized, Congress engaged in a fairly rigorous review of voting practices in the jurisdictions that had been covered by Section 4. And what they found, many of the representatives and senators said, surprised them. They were surprised at the level of voting mischief that was still happening in jurisdictions around the country. So they held field hearings, they held hearings in the United States Congress over 9 months. They heard from 90 witnesses, they assembled a 15,000-page record, and based on that record, Congress decided in 2006 by a vote of 396 to 33 in the House and 98 to 0 in the Senate to reauthorize the provisions of the Voting Rights Act. And yet in 2013, the Supreme Court decided that Congress must be wrong. The court decided that times have changed and that the Voting Rights Act, at least this provision, functioned as a stigma on the South and struck down this provision despite the record that Congress had developed. Now, this was important in part because we knew and Congress knew what would happen if this provision were removed. But it's also disturbing just from the standpoint of those of us who litigate. A record was developed in this case, a record that strongly supported what Congress found. This was not a fly-by-night decision. It wasn't an assumption by Congress. It wasn't what a majority of the Supreme Court said it was, a formula based on history. It was an assessment that Congress did of voting in the country from 1982 to 2006, and yet the court wiped it away with the stroke of a pen. Within 2 hours of the court's decision, the Attorney General of Texas first tweeted and then announced his decision to resurrect Texas's voter ID law. And we can talk about that a little bit more in a moment. So that's a legal problem. And essentially, since the Shelby County decision, jurisdictions all over the country have engaged in voting changes that would have been disqualified under Section 5 of the Act. And actually, if you want to see what some of these changes are, you can go to our website, which is www.naacpldf.org, and we keep a running list of the voting changes that have been happening so that you can see what the effect has been. So that's a crisis of law. Even in the context of the issue that has been gripping this country for the last 18 months, the issue of police violence against unarmed African Americans, there are very serious problems with the law that governs these cases. The standard set out by the Supreme Court and subsequently interpreted by jurors and judges has resulted in, I think, an embarrassing failure to hold accountable officers who've killed unarmed African American civilians. The law allows officers to use force to subdue a threat, but even the supposedly objective review of that threat fails to take account of the myriad ways in which who we deem to be threatening is deeply influenced by sometimes explicit but often implicit responses to race. The studies that show that police officers routinely add 5 years to the age of a young African American man, that means when they see a 13-year-old, he appears to them to be 18, demonstrate that there are deep-seated ways in which implicit bias influence how we see threat. And it's one of the things we're thinking about and trying to work on, how to infuse this reality into litigation in terms of jury instructions and legal standards. And so our law has to be revised and amended and interpreted in ways that allow us to take account of this increasingly well-documented and studied phenomenon of implicit bias and an understanding of how that bias colors the content of a neutral analysis or an objective analysis of threat. So we have a crisis of law, but we also have a crisis of men and women. It's not just that the law says that there are certain things that can be done or not done. It is the willingness of men and women, leaders, to take advantage of these opportunities or not take advantage of these opportunities. It's the politically expedient response of men and women in jurisdictions throughout the country who responded to the SCOTUS Shelby decision with the rash of new voting changes, as I said, that would never have passed muster under Section 5, measures that make it more difficult for African Americans and Latinos to participate in the political process and elect candidates of their choice. Yes, it's the Texas voter ID law that I just described that required us then to file suit, which we did under Section 2 of the Act, challenging the law. Just a little history, this voter ID law in Texas is a law that we had actually challenged under Section 5. Now, Section 5 was an administrative process. You had to simply tell the Attorney General that you wanted to make this change, and the Attorney General would make an assessment of its effect on minority voters. He might ask various groups in the community for information, and there would be a determination that was made. And we had been successful in ensuring that Texas could not use this law under Section 5. But after the Shelby decision, the Attorney General of Texas decided to resuscitate the law. And so now we had to file suit, which is precisely what Congress did not want when it enacted Section 5. Congress created an administrative process that, for the price of a stamp, allowed a jurisdiction to simply inform the Department of Justice of their intention to make a change and to receive either preclearance or not preclearance. Now we had to file suit, and we did file suit. And in November of 2014, a federal district judge in Texas wrote a 93-page opinion finding that Texas's voter ID law violates the United States Constitution in that it was enacted with the intention of inhibiting the ability of African Americans and Latinos in Texas to vote. The court also found that the law violates Section 2 of the Voting Rights Act. The state appealed to the Fifth Circuit Court of Appeals, where we won again last year. The Fifth Circuit, not known as a bastion of liberal jurisprudence, nevertheless ruled that, in fact, the district court was right, that the law violates Section 2, and they remanded back to the trial court the issue of intentional discrimination for further evidentiary presentation. So you might say, so great. The Supreme Court's decision wasn't so devastating. You were able to file suit and you were able to stop Texas from applying this voter ID law that was discriminatory. Well, first of all, the case is headed to the Supreme Court, so it's not over. The state of Texas has no intention of accepting the decision of 2 federal courts in this matter. What does that mean? It means that for 3 years, Texas has been conducting an election that at least one federal judge found was created for the purpose of discriminating against minority voters, and that an appellate court found violates the Voting Rights Act. At trial, our expert testified, and the trial court recognized that there are approximately 800,000 voters in Texas who lack the requisite ID to meet the law's requirements. This is the law that no longer allows Native Americans to use their tribal ID to vote, that doesn't allow our clients who are students at Prairie View to use their university ID to vote, which they had been able to use previously, but does allow you to use a concealed gun carry permit to vote. 800,000 voters. I've lived in Baltimore for 20. There's 650,000 people total in the city of Baltimore. There are 800,000 eligible voters in Texas who do not have this ID. And there has been election after election since 2013, despite our efforts to get an injunction. So what does that mean? One of the interesting things about voting in this country is that most people don't pay attention unless there's a presidential election, but I started my career at LDF as a voting rights lawyer. And for that reason, I understand that the way power is exercised and authority is exercised over the lives of the people that I tend to represent is largely through the school board and the county commission and the water commission and the town council and the constable and the justice of the peace and all the judges. And all those elections are happening while this discriminatory voter ID law is in place and while 800,000 voters are disenfranchised in Texas. And of course, we've had to use the very limited resources of civil rights organizations like LDF and others to attain this victory, precisely, again, what Congress wanted to avoid. We just filed suit in Alabama a month ago challenging their voter ID law, which we also contend was intentionally created to discriminate. And Alabama, once again, just like Texas, only attempted to impose this ID law after the Supreme Court's decision in the Shelby case. They need not have done so, but political expediency and a refusal to protect above all else the right of every citizen to participate equally in the political process, the right to vote, which Congress in 1888 said is fundamental and preservative of all rights. We saw it here in Georgia with attempts to close polling places in Baker County and Morgan County, and with efforts to pass a law that would have even more severely restricted early voting. And with really the great work of tremendous local activists, we were able to beat back many of these efforts before they went into effect. So it's not just the law, it's the willingness of men and women, of leaders, to engage in this conduct. And it's not just the legal standard governing the use of force by police officers that fails to take account of racial bias that may warp an officer or even a jury's sense of what constitutes a reasonable threat. It's, after all, not just that Timothy Loman killed Tamir Rice within 2 seconds of pulling up at that park, but it's also that he then grabbed Tamir's 14-year-old sister, who was screaming and crying and in despair, and handcuffed her and put her in the police car. And that he told Tamir's mother, if you don't stop screaming, I'll arrest you too. It's not just that Officer Van Dyke shot 16 bullets into Laquan McDonald as the young man walked away from him in Chicago. It's that 5 other officers corroborated Van Dyke's false account of what happened. I was just reading their police reports and describing how they claim McDonald was walking towards Officer Van Dyken threatening him, how he continued to turn the knife in a threatening manner towards the police officer. You've seen the video. Didn't happen. So we're truly in a time of peril, and we have choices to make about the direction of this democracy. We've been faced by moments like this in the past. And we have, in too many instances, when we face these moments, made the wrong choice. Like the choice after Brown versus Board of Education in 1954, when almost the entire South turned towards massive resistance instead of towards an effort to knit our country together. And I think we're living today with the fallout from those choices. Fallout that takes the form of hyper-segregation, both residential and school segregation, and fallout that is exemplified in the gulf that exists between us. It's in that gulf that Tamir Rice becomes a menacing 20-year-old, and that his sister cannot be a grieving teenager. And it's my belief that we can no longer, as a nation, afford that costly separation. We simply can't afford it. So in the position that I'm in now, leading this extraordinary and great organization, I am always intimidated by those who came before me. So I'm happy that you didn't mention Thurgood Marshall in the introduction, which most people do. But I'm always looking for inspiration, and it's one of the reasons why I love Martin Luther King Day, even before I took this job. I just love it. Because as soon as the new year comes, I start looking for my CD collection of King's speeches, getting myself ready. And I reread my favorite ones. I read Letter from a Birmingham Jail and Give Us the Ballot and many others. And I find in them always just what I think what we need. Words of encouragement, tough words, honest words about the struggle we face, insight into the nature of humankind, truth about power and activism and the damaged soul of this country. I think my greatest annoyance at the effort, which increasingly I think is deliberate, to neutralize Dr. King into slogans and dreams, is that it denies the awesomeness and humanity and vision of the man and strategic thinking of the man. And too many people simply don't know enough about the depth of his messages to draw strength and encouragement and strategic clarity from them. And this year I've been taken with Dr. King's efforts to try and understand the despair of young people. And I've been taken with this because we have been, over the past 18 months, really seeing young people engaged in protest and engaged in hard questioning and dissatisfaction and doing the things that young people do. And Dr. King was very attentive to this same phenomenon in the period that he lived. And he wanted to understand, in particular, not just the anger, but the despair and the disappointment that young people felt. He even wanted to understand the motivation of what he called the hippies. He wanted to understand the anger of young black radicals who eschewed his calls for nonviolence, those who were disillusioned and even nihilistic. In a discussion broadcast on Canadian television in 1967, Dr. King talked about the way in which young people, specifically young black people, had awoken the country from a kind of what he called mediocrity and convention. I think that's the good old days that lots of people talk about, the 50s, right, the good old days. That they had woken the country from a kind of mediocrity and convention, and from what he called a blanket of conformity and intimidation. And he lauded the protesting spirit of young people, even when he disagreed with their tactics. Even the hippies, Dr. King reminded us, in what he called their flight from reality, were expressing a profoundly discrediting judgment of our society. He reminded those disturbed by the protests of young people that it was those young people, particularly young African Americans, that prodded this country into action, to see itself, to see the unfinished business of this democracy. He credited young African American protesters as having inspired young white people to create the peace movement. And so too today are young people pushing against convention and the status quo. That fire was kindled in many young African Americans after the killing of Trayvon Martin. Their outrage at the death of this young man, innocently walking in his father's neighborhood, and the impunity for the killer, shifted something deep in their spirit. Mike Brown's death in Ferguson may have looked like it was the beginning, but the foundation of the outrage, the demand for change and the insistence on unmasking the face of injustice in our society was laid when young people donned hoodies all over this nation in solidarity with Trayvon Martin. And the protests of young people in Ferguson and Baltimore, Cleveland, now Chicago, has without question contributed to a tense environment in our country. When those protests have erupted in violence, and this has been, by the way, very rare, it has been, of course, unfortunate. And there has been, particularly in Baltimore, what I think of as an inordinate focus on property damage during the Baltimore unrest. And Dr. King, when he was looking at the riots that had taken place in '66 and '67, actually spoke to this issue, and he talked about the difference between property and human beings and the sacrosanctness of human beings, while understanding the importance of property, recognizing it was not the same as human life. And he was disturbed even then by the focus on property damage. And he said, the focus on property in the 1967 riots is not accidental. It has a message. It is saying something to young people, perhaps about their own value. I would say that the protests we've seen have not created the tension, but in the best tradition of civil disobedience, they have brought existing tension to the surface. And I remember that Dr. King said in a letter from a Birmingham jail that he had no fear of tension, that he said there is a type of constructive tension that's necessary for growth. Despite my belief in the power of litigation and legal advocacy to make change, and I do believe that legal change leads to changes in behavior and structure, I also believe that the uncompromising voices of young people, even when I don't agree with them, wakes us up from our lethargy and is necessary for a rigorous self-examination in our country and for meaningful change. But those protests are only part of what's necessary for change. But I think it's important that we not pretend that they have not drawn us to see things that either we didn't know existed or we didn't want to see. If many of you are honest, you will admit that before Ferguson, you probably did not know that there were entire towns that used the police department as the primary source of revenue through ticketing. You didn't know about the bail system that turns people into lifelong debtors and even felons. You were perhaps shocked by the video of Walter Scott being gunned down in that park in South Carolina. You wouldn't have believed someone who told you that police officers would choke to death an unarmed, nonviolent grandfather in broad daylight in New York City and not be criminally charged. All of this has been brought to light by the young people brave enough to film some of these incidents and to protest about them. In fact, in 2013, when I started at LDF, I actually thought that would be the year that we would begin talking about police violence against unarmed African Americans. We filed an amicus brief in the Supreme Court in a case involving the shooting of Robbie Tolan. Have you ever heard of Robbie Tolan? If you have, raise your hand. One person. Robbie Tolan was a baseball player, Major League Baseball player. Actually, his father had been a Major League Baseball player also. And he was 23 years old, and he was driving back to his parents' home in Bel Air, Texas, in a nice car because his parents were fairly well off. And police officers followed him to his parents' driveway, and they wouldn't believe that this was his home and that this was his car. His parents came out and said, "That's our son. This is our home. This is our car." And a police officer came at Mrs. Tolan, his mom, and Robbie shouted something at the police officer, and he was shot. You haven't heard of him because, of course, he never played baseball again, had a very long recovery. He is still alive, and he filed suit against the police officers. And we filed an amicus brief in that case, and that year I thought, this is it. He's a baseball player, like it's America's sport, you know. He comes from this really middle-class home, and his parents were there, and this is going to be the year we talk about it. But most of you have never heard of it. And this is the year before Mike Brown was killed. So the truth is, I'm asked all the time, you know, why have we seen these incidents happen? We've seen them happen because you've seen it, because you've now seen the cell phone videos, or you've seen the dash cam videos. Those of us who've been doing this work and who've been litigating in this space and who've been talking about it have known that it happened. I'll tell you a quick story. I went to Ferguson in the fall of 2014. Actually, I was scheduled to go before Mike Brown was killed to speak at Wash U and to speak at a museum in St. Louis. And then Mike Brown was killed, and so I was obviously going anyway. And I was asked to do a lot of media. And one of the things I was asked to do was to do an interview on public radio, in St. Louis Public Radio. So I went to the station to do this interview, and the host asked me the question I am literally asked in every interview, which is, you know, do you believe that police violence against unarmed African Americans is increasing? Is this something new? And I said exactly what I said to you. No, I actually think that, you know, it's because of the videos that we're seeing it, and that this is an issue that has been underground talked about in the African American community for decades. And while I was having the interview, I spontaneously said, to be honest with you, the first time I remember even thinking about this issue was when I was 10. And I grew up in New York. And I remember that a young boy was killed by a police officer. And I remembered it because the boy was 10 and I was 10. And I remembered that the officer's name was Shay. And I remembered what the newspaper looked like on my parents' coffee table about it. And I remember the conversations at the bus stop going to school. So I'm in the 5th grade. I hadn't thought about it in a while, but that was kind of my first formative understanding of what that relationship could be. So I said it on the radio show. When I got back to my hotel room, as Professor Brown's already told you, I am on Twitter, and I checked my Twitter feed, and someone had been listening to the show and said, I found the case. And they sent me a link to an article in the Daily News about the death of the boy, whose name I had forgotten, but whose name was Clifford Glover, and who had been walking with his father on a Saturday morning. They used to go and collect metal scrap and trade it in at a junkyard. When a car pulled up next to them, an unmarked car, 2 white men got out of the car, not dressed as police officers, began to chase them with guns drawn. They ran, they shot the boy, and the officers began to exult, we got him, we got him. And then when their supervisor came, he said, well, can't you see he's a kid? And they said that they thought he fit the description of a robbery suspect, and this is one of the rare cases in which an officer was actually indicted and went to trial in New York. He was acquitted, he was not convicted. But I remembered this incident, and then one of the listeners kind of sent me this article, and I was stunned at how much I did remember, that I was actually right about the officer's name. I mean, I hate to reveal my age, but that's over 40 years ago. And I still remembered the officer's name. So it's not a new thing, is what I'm trying to say. And that's important to understand, that there are underground conversations about injustice happening in communities that were brought to the surface over the last 18 months and brought to the surface by young people. But this reality that this can happen, this should be the shame of the legal profession. You know, all the things I just talked about, the bail system, and people using the police department to raise money for a town. And so as I said, we have a crisis of law and a crisis in the hearts of men and women, and I can't sugarcoat that we're in a difficult, challenging, and sometimes deeply dispiriting moment. How do we confront such a moment? And that's the question I'm faced with every day. I'm leading an organization of about 22 lawyers who are brilliant, could have worked at any law firm they wanted to, but chose to do this extraordinary work. They are not paid well. They are tireless as they work across the country on civil rights cases. I'm mindful of those who came before me and the work that they did and how difficult it can be. And I constantly feel the need to inspire my staff, to inspire myself, to inspire you to believe that this is actually our moment, that this is what we're built for. I truly believe that in this moment of crisis is an extraordinary moment of opportunity, and I wake up excited about it every day. So how do we confront this moment? Well, first of all, each of us must regard it as our obligation to do our part to contribute to who we are going to become as a country, especially those of us who are lawyers, because we are given the responsibility of leadership, even when we don't deserve it. But all over the world, and especially in this country, lawyers play an inordinate role in shaping and molding and shifting the foundations of democracy. We simply don't have the luxury of turning away from this moment simply because you're a corporate lawyer or a law professor or in-house counsel or a judge or a mediator or a prosecutor or a defense counsel. There's still a role for you to play because we're truly facing a critical moment for our democracy. If you're a bankruptcy lawyer, I could have used you last year when Detroit was in bankruptcy and we were trying to get the water turned on for the 70,000 people who were getting their water turned off. And we had to figure out, how do you do this when every matter that involves city services has to go through bankruptcy court? I could have used you. And some of the best help that we've received over the last year has been by law professors who volunteered their time and helped us read grand jury transcripts so that we could really know what we were talking about in every case. There's a role for you to play, and if not with the Legal Defense Fund, with many other organizations or in your own work, but you must do it. Because we're at a moment where we have choices to make. Right now, we finally achieved a bipartisan understanding that mass incarceration must end. But how will we end it? There are bills right now in Congress slated to pass this year. And ask yourself, do you know what's in them? What are the terms that we've chosen to try and end this embarrassing incarceration rate in our country? What will we provide for those leaving incarceration? How will we help them start again? How will we provide for those who remain incarcerated? Do we think we have any obligation to provide a humane environment that might encourage them to go another way? How will we end the school-to-prison pipeline that leads so many children into the criminal justice system? What investments are we prepared to make to elevate the life chances of those who are most marginalized? Do we really care about our children when we make the decisions that we make about school funding, or when we mete out harsh school discipline to poor Black children, when we allow our cities to be places of deep distress and economic dislocation? And can we truly care about our nation's children if we don't also care about their parents? We have to answer those questions. We have to answer the questions about justice. Earlier, I guess not this year, now it's last year, I worked with the ABA president, then ABA president, to convene a meeting of prosecutors who I believe need to be engaged around this issue of racial bias in the justice system. And it was a private meeting, so I will not share with you all we talked about. We did come out of it, though, with a statement of principles of things we think prosecutors can do to deal with the issue of racial bias. Prosecutors have an extraordinary amount of discretionary authority, and whether it's Brady obligations to hand over exculpatory evidence or Batson issues in terms of the removal of African Americans from juries, or whether it's simply being the prosecutor who knows who the bad cops are, knows who the good ones are. Prosecutors have a role to play. And that meeting with them was really important. It showed me the way in which this cannot be a narrow conversation among civil rights lawyers. It has to be all of us. And when I met with the prosecutors, I said to them, what is the truth? I said, you have to understand, I'm a lawyer like you. We're on the same, we took the same oath, uphold the Constitution. And when I'm out in the communities of people I represent, I believe in the rule of law. So I am always encouraging them to let the legal process do what it must do. And I told the prosecutors, but you are making me look ridiculous. Because every time it doesn't work, every time someone is exonerated after they've been in prison for 20 years because the prosecutor didn't hand over exculpatory evidence, you ruin my credibility to ask people to believe in the rule of law. And I asked them to work with me, lawyer to lawyer, to try and change that. And I was very proud that some of them have vowed to do it and have been very helpful. As lawyers who've taken the oath to uphold the Constitution and laws of this country, we have to ask ourselves, can we be stewards of a justice system in which racial bias continues to play a vital role in whether someone is arrested, convicted, incarcerated, how long they're incarcerated, whether they receive the death penalty? Who will take responsibility for ending injustice in the legal system if not lawyers of every kind, not just civil rights lawyers? And so, since the end of last year, I've been meeting with lawyer groups and talking about the need for lawyers to take seriously the oath that we all took to uphold the Constitution and the laws of this country. I remain optimistic. Like Dr. King said in 1967 about the protests of young people, he said, "The spirit is awake now. Structures will follow if we keep our ears open to the spirit." I would add, and if we also will put our hands to the plow, this is work. At LDF, we're working virtually around the clock, but we need your help. I'm encouraged when I hear about the Ferguson course that you all taught here at Emory, at University of Maryland Law School, where I'm still on the faculty. They very quickly put together a course called Freddie Gray's Baltimore to really help explore the complex set of systems that led to that encounter. It really wasn't about the case, it was about all of the structures in Baltimore that led to that encounter. I've been encouraged by so many who called to help, by lawyers and law professors that I call around the country just to find out what are our chances in a particular court and what's the procedures that you use there that are not in the book, and can you help us think through this thorny issue? And what's going to happen if I file this? You know, tell me what you know. And people have been so open and so willing and so desirous of being a part of it. The pro bono help that we receive from some of the most prestigious law firms in the country has been wonderful, and we value it tremendously. And there's a way for you to play a part, too. Whether you're a lawyer or not a lawyer, you are a citizen. And citizenship requires that you work for the bettering of this democracy. I can't tell you how to do it. You know your skills, you know your life, you know your community. You know the best way that you can play that role. But I must insist that you do it. That you not leave it to those of us who are full-time civil rights lawyers or activists. That you take your citizenship role seriously, that you join us in the work of democracy maintenance, and that we fulfill not Dr. King's dream alone, but really his work, his vision, his power, his humanity. Thank you. Thank you. Thank you. I would love to take questions if you have any. Yes, ma'am. I think there are microphones. You have to come on down. And while she's coming, somebody think of a question. Hi.
And I apologize if some of the questions I asked you answered already, because I got off work late and got here late. But my name's Natasha. I actually just moved to Atlanta in June, and I just finished undergrad in Kansas. So a lot of what you're talking about was definitely a huge part of things that were going on in my own personal community. And I have been on this sort of journey regarding social justice, and I'm really glad that I chose to come tonight. And some of my questions are dealing with how do you, while working in this system, deal with the emotional and mental aspect of taking on all of these cases and dealing with sort of infiltrating all of these structures of colonialism and capitalism that affect your very own community, while at the same time wanting to benefit from those structures without exploiting the people who you're trying to help. And that's kind of where my head has been at lately. And I just went to a housing justice meeting over in Peoplestown, and there were a lot of folks talking about the gentrification that's happening in their neighborhoods. One woman, her roof is literally falling in, and her kids can't sleep at night because there's insulation falling on them and they can't breathe. And another woman has a pile of sewage in her backyard and no sink. And she was literally told by the judge, you have to get out. You have 3 days and there's nothing I can do. And these are issues that I never would have known about, you know? So I'm just curious as to, like, what would you say the strategy is with wanting to thrive, wanting to have success for yourself, while at the same time, you know, working to make sure that your community is not being erased?
So one of the things, and thank you for that, Natasha, and I feel your struggle. And one of the things I think is really important is that you see who you are in this. And for me, that means you have to recognize your own privilege, and you cannot become paralyzed by it. You know, one of the things that's awkward about being a civil rights lawyer is that, you know, you go to communities where you're helping people and you're representing them, and my clients are just amazing. First of all, they're brilliant. They're so smart. They know exactly what's going on, but they treat me like a queen. And they just, you know, they're so wonderful. And, you know, thank you for what you do. And I think that's crazy. Like, I'm going to get on this plane and go back to my home, and you've got to stay and live with all the stuff you're talking about, right? So, so first of all, you just have to know that yourself, so that you're walking in your own honesty. But you also cannot do isms 24 hours a day. You can't do, like, colonialism and racism and sexism, and, like, you have to get on with the work. There is a really important part of doing this work that means you have to be kind of double-minded at all times. You have to be able to do the work, and you have to be able to live. And I increasingly think that, you know, that's kind of like the revolution, is being able to live through this thing and being able to thrive in it, being able to enjoy it, being able to love your family. You know, there's a lot of great civil rights lawyers who are, you know, divorced and families broke, you know, like, it's hard. So part of it is figuring out how do you maintain your humanity in it. And that means you have to also be able to live. Now, you only know every day what's true for you, you know, what you can tolerate and what you can't tolerate. I frankly love having humane, bright people working in all kinds of different structures. I just love, you know, because I never know when I have to call somebody at Bank of something something to tell me something, right? So, I mean, you know, so I don't want everybody to become a civil rights lawyer. I want people to be out there in all the structures of this country, trying to make a difference and trying to make things better. And so a lot of that work is happening inside you, and then some of it is the work that you're actually doing for somebody. And you have to kind of maintain a balance between those things and know who you are. But there is no nobility in driving yourself insane or making yourself ill or actually living in a spirit of guilt about your own privilege. You have to recognize it. You have to see it for what it is, not pretend to yourself. But you also can't let it paralyze you from actually being able to contribute in the ways it sounds like you want to contribute. in terms of seeing the awful conditions that people can live in, seeing the awful things that can happen to people, you know, that's very hard. I find that it's actually harder for me to pretend it's not there. That's actually more painful for me. Now my kids would tell you that makes me kind of a bore sometimes because, oh, Mom, no, you know, every movie I watch, you know, but I like to, I'm very committed to reality, so I like to live in that truth. And, you know, but you have to know when you have to get away. I watch a lot of football, you know, I mean, you have to find your thing that, like, you know, you have to find your thing that allows you, that's so separate from anything that has to do with who you are, really, that you almost find relief in it. And now, actually, football's turning into something I can't enjoy either. But the point is, tennis. The point is, you have to find your thing. And, you know, you really do have to be good to yourself and figure out how to do this work for the long haul. So that's what I say.
Thank you very much.
Yes, ma'am.
Thank you so much for coming.
Thank you.
I'm Savannah Potter Miller, and I am a co-chair of the Women in Criminal Justice of the American Bar Criminal Justice Section, and we certainly welcome you.
Thank you.
Thank you. You have been very sort of understated as to the importance of the NAACP Legal Defense Fund in Georgia. You've been very polite, but would you just...
I heard this was the South. I had to be polite and understated.
Would you give us a little hammering as to the great history of the partnership and collaboration of the NAACP Legal Defense Fund lawyers in Georgia? I was hired by Howard Moore, Donald Hollowell's law firm. Would you just give a little light for those who are under my age to history of that and importance?
Well, actually, thank you very much, and it's a wonderful moment to be talking about that history, because just Saturday was the 55th anniversary of the day that Charlene Hunter Galt and Hamilton Holmes walked into the University of Georgia, escorted by Vernon Jordan. They were represented by Constance Baker Motley, the great LDF attorney, and Donald Hollowell, our cooperating attorney in Georgia, and that's the way LDF has always operated. Our headquarters is in New York. We also have a DC office, but we have always worked with cooperating attorneys in states all over the country, which is why we travel so much. So, you know, Fred Gray was our cooperating attorney when we helped represent the Selma Marchers and Rosa Parks, and here in Georgia it was Donald Hollowell. And actually I was just reading Constance Baker Motley's account of her work on that case, and actually the trial, let me get this right, the trial was in Athens, and what I remember is that she had a 75-mile drive to go to court every day, there and back. And the first day that she appeared in court, I think this was the case where the judge just closed his eyes for while she was being introduced, because you had to be introduced by the local counsel. But she prevailed in that case, and Charlene Hunter Galt, who's a great friend of the organization, and came together with us last year for the 60th anniversary of Brown versus Board of Education to talk about her experience desegregating the University of Georgia. And actually, there's a whole roster of work that we have done in Georgia and that we're doing in Georgia. In fact, we have 2 voting rights cases happening right now in I want to say Fayette, Georgia. And our partnership has been really terrific, especially around the Voting Rights Act over the last 18 months. We worked with the social action chapter of the Deltas here in Georgia, who really helped us when we were pushing back against the effort to limit early voting. Shirley Sherrod in Augusta is a great resource and mentor for me around a whole series of issues of just being a woman and leadership and so forth. And we've just had a very close relationship over LDF's 75-year history. I should say last year was our 75th anniversary. and the relationship that we've had in Georgia, all the relationships that we've had in Georgia have been very, very strong and remain very, very strong, and is a powerful part of our history that we're very proud of, so thank you.
My name's John Michael, and you make me believe in democracy, which is, of course, if without it, it seems like there is no real hope if we're not holding people accountable. And my favorite saying by Dr. King, injustice anywhere is a threat to justice everywhere. Well, we face that here, and you have been polite. I was on the original Citizens Review Commission in Atlanta after Katherine Johnson, the 90-plus-year-old woman, was shot 53 times, and I did get to read the report and many other egregious reports. So my question centers around that because we need more of this here, and there's very little comprehension of how much goes on behind the lines when you bring a civil case or a civil rights case against a police officer. And foremost amongst that is that the grand jury, this is the only state where after the case is presented and the officer in question, who is really the defendant, is sitting there, that you can't ask him any questions after he speaks to the grand jury as the lone person to speak to them. You cannot question him. So I want to know what we can do about this, in that every time, no matter where it is, that I see these cases, and I'll soon be 70, my blood gets boiling, but I want to do something more than just be an activist. And here, the laws have been twisted in many ways because the legislature and the government are totally right-wing here now. We don't have a single Democrat from governor to secretary of state. In the state house and the state senate, it's close to 70% in control. And so we do things like build $1.5 billion stadiums next to a 22-year-old stadium that's perfectly good shape without a vote. In the area the lady spoke about in Peoplestown, I went to a meeting there. The council person claimed she didn't know the Braves were moving. And the mayor—
She didn't know the—
He didn't know the Braves were moving 13 miles away. She did not know. And the mayor is making promises and working with Georgia State. All that seems well and good, but no affordable housing has ever been built there. None. They've never worked with that community in the city. So in cases where they are so egregious and we don't get a vote, what would you say to us? And thank you.
Yeah, thank you. So I don't want to, I guess I want to say that first, some of the structural problems that you're talking about the grand jury and so forth, they existed even before you didn't have any Democrats in office. That's a structural problem that we have to be honest about. And that's true, and not just in Georgia, right? That's, in Cleveland, where they did not indict the officer who killed Tamir Rice, the officers were allowed to submit a written statement to the grand jury, no cross-examination. So, so the first thing is to recognize that many of the problems that we see, particularly around the criminal justice system, are actually not partisan. They're actually problems, many of them, that were reinforced and entrenched by Democratic leadership as well as Republican leadership, and they really have to do with a narrative that we have about criminality that's associated with race. So I just want to lay that foundation, just because that, to be fair, that has to be said. Nevertheless, your point is really well taken about how you move things when the political structure doesn't allow for that movement, the local political structure doesn't allow for that movement. When Mike Brown was killed in August, he was killed on August 9th, I think on August 14th, we submitted a letter to the Attorney General, who was then Attorney General Holder, and we went to see him for a private meeting. And I'm a big believer in understanding the role that the federal government can play in moving jurisdictions where you're not going to have the local political clout to do it. The principal way the federal government, in my view, has power is through money. And I'm not ashamed to say that, nor do I think that that's not a tactic we should be exploiting. So we went to see the Attorney General to talk about the more than $1 billion that the federal government gives in grants to police departments around the country. And they do it every year through the Burn Jag program. And we went into the statute and we understood that they couldn't condition money on certain kinds of things, but there were other ways that they could influence the money. And we set out for the Attorney General all the ways in which we think that the federal government has the power through that money to change local jurisdictions because they want the money and they get the money. And we've had some success, but not real success. It's a lot of money. $1 billion is the minimum. If you really want to make those kinds of changes, at least in my view, it requires two things. It requires the federal government to get serious about their money. Title VI of the Civil Rights Act of 1964, to me, is one of the most powerful tools and unused tools the federal government has. I know that it's powerful because, like many people who went to school in the North, I was bused to school beginning in 1968, as many kids were in New York and Chicago and other places up north, because of the Civil Rights Act of 1964, not because of Brown. It was because the Title VI of the Civil Rights Act of 1964 said that the federal government could not give any money to any state or local program that engages in discrimination. And because they wanted the money, they started integration, which lasted for a brief period of time. And that's how I was bused to an integrated school. Title VI prohibits the federal government from providing funds to any program, local program, state, municipal, that engages in discrimination. No police department, no prosecutor's office, no department of any kind that receives federal funds should receive those federal funds unless they can make clear to the federal government that they're not engaged in discrimination, in racial discrimination. And that power is underutilized by the federal government. So we set out how this could be done with police departments and with all of the police money. I do think that there is a fear, a political fear, to get down to the political piece, particularly among Democrats, of seeming like they're not sufficiently supportive of police officers and law enforcement, not sufficiently supportive of prosecutors, and so they tend to be more reluctant in some instances to make these kinds of changes. But we have not stopped pushing on it. It's one of the reasons why I'm so distressed about the criminal justice reform bill that is currently moving through the system that actually says nothing about policing at all. So one of the things I think is, therefore, that there has to be this federal government piece. The second piece is exactly what I was talking about earlier, which we're trying to do with prosecutors. The work we're doing with prosecutors is completely separate from any federal system. This is about state prosecutors. We are bringing people around the table who would not be people you'd think would want to be around the table. And we're looking for ways to kind of infiltrate and deal with the practices in their offices. And I think we have to do that. We have to figure out some way that we can engage, at least for me in the prosecutor's realm, I'm doing it on a professional level, professional to professional. But there has to be some way that you can engage and expose the realities that you're talking about. I think judges also bear a huge responsibility. They also know, the young lady was just talking about the judge in Peoplestown, they know what's happening. It was the judges knew what was happening with the bail system in Ferguson. They knew that these officers were using this ticketing. What was their obligation and what was their responsibility? Well, most of those judges are elected. But if you ask most people, even people who care about justice and equality, to name 2 judges they voted for, they couldn't tell you. So I think we have to actually be more targeted and focused in our look at who actually wields power and what are they doing with that power. And we have to make examples of those individuals so that people will fear what will happen to them if they don't exercise their power appropriately. But finally, I'll say this. I'm a big believer in winning. I think we have to start winning. And that's hard to say at this time. People say, how are you talking about? How are you going to win with all the things you just talked about? And Hank Sanders, who's a great voting rights activist in Alabama, he and his wife Rose we were at the 50th anniversary of the Voting Rights Act of the Selma March in last March. And he said something that just stayed with me. He said in 1964, they had all the law and all the power and all the dogs, and we still won. And so I think that all of the righteous fervor and the blood boiling that you're experiencing, we have to stay at it. We have to stay at it, and we have to allow ourselves to believe that we will get some successes that we then can parlay into a moment. Nobody believed that we would be talking about mass incarceration in this country in a bipartisan way in 2015, but we were. Nobody believed that we could end stop and frisk in New York. It wasn't something sudden that happened. That was 10 years of activism, of exposing the stories of young African-American men who were stopped and frisked 20 times between the age of 14 and 20. It was a communications campaign. It was a litigation campaign. It was all of those come together. And we were able to transform the vision of what was happening between police officers and young African-American men. So I just believe we have to be as tenacious as ever. I'm a big believer in campaigns. It's one of the things that LDF is launching now. We've launched something called the Thurgood Marshall Institute so that we have strategic communications and organizers on staff and our own researchers so that we can even develop our own research, so that we're not just engaging in litigation, but that we can put together whole campaigns around discrete issues and discrete locations. I just think we have to be more strategic, more determined, and we have to believe that we can do it.
Thank you.
Thank you.
So what we'll do is is it okay if we take the two?
Oh,
people
sure,
at the
sure.
mic, the two people that are at the mics.
Yes, ma'am.
So I'm Mary Dujak. I'm on the faculty here, and we are so thrilled and honored that you're here with us today. I love your point that we should not just pay attention to Martin Luther King's dream, but do the work of democracy, and that the work of democracy is not just happening out there, right, but it's happening here. Ideally, it's happening, for example, in law schools. So I was wondering if you could share your thoughts about, since most American law schools have still not thrown off the legacy of discrimination within higher education, right? We're still not it's not all rooted out, those past years of intentional or unthinking discrimination. And so even administrators who are trying really hard to be sort of inclusive nowadays are working with this sort of past that we can't erase. Mm-hmm. So if you were able to sort of give a plan for doing the work of democracy within institutions of higher ed like law school, what are the most important things that we would do?
So that's easy. First, know your history. And that means everyone in the institution should be responsible for knowing what the history of that institution is as it relates to race. What did you do? Ask the question. And that knowledge, that history, should be documented somewhere. It should be given to every admitted student so that students know when they walk in the building, what was this place? Who were we? How are we received and understood out there in this community based on that history? Because who people think you are doesn't necessarily come from what you're doing today, it comes from who you were. So I think, and I know that is something that a lot of schools don't do. They do not engage their own history. You know, one of the great things that Ruth Simmons did at Brown was the, history of Brown University around slavery, but we did it with Thurgood Marshall sued University of Maryland Law School in 1935, so we couldn't really pretend we didn't know, but we did a whole thing on the history, not only of that suit, which was kind of the first suit on the road to Brown, but then the efforts of the university to resist desegregating through the 1930s and into the 1940s, and understanding that history. We did it at the 50th anniversary of Brown. Is really important. That needs to be documented, needs to be disseminated. People need to be familiar with it. A new dean who comes on needs to get it, and all the new students need to know who that institution is. Secondly, the issue of implicit bias, because that's the space where people can talk about it more comfortably, because we all have it, is really such fascinating brain science that if you are an academic, you should be interested in it. And So you should be bringing in all the fabulous people who do wonderful presentations about implicit bias, and they can show you precisely what the studies have shown. They can show you how it works. Look, here's the reality, and this is true about bias across the board. It's not about whether you're a nice person or a not nice person. It is about the discipline that you have to utilize and access as you go throughout your day. Everybody engages in stereotyping other people. You know, if somebody walks in here and they're 7.5 feet tall, I wonder if he's a basketball player, right? So we all do it. We all do all kinds of shortcuts. The difference between those of us who are trying to live in the world in a responsible way is that we are quite open to having our mind changed, right? And we don't stick with the stereotype. That a conversation will reveal something to us that says, oh, that's not that person, and we're willing to change. We're not holding on to that image. But that actually is something that you maybe were taught by your parents, or something that you decided to do yourself, or that you learned, but you had to learn how to do it. And there are people who are not doing it, who are taking the shortcut, and who are allowing themselves to stay in their ignorance. And they have to get off the dime and do the work. But some of them have to be taught how to do it. So that's number 2. Number 3 is learning how to talk about talking about race. So I talk about race all the time, and thus I'm very comfortable talking about race. Most people are not very comfortable talking about race. And one of the things I've learned how to do is to try and be a trusted guide to help people talk about race in a way that's honest, but in a way that recognizes that people don't share my level of comfort. So I think not that everyone has to be comfortable, but you have to have the conversation about the fact that it's uncomfortable, and have people help think through how you have more comfortable. It should be uncomfortable, right? But how you can live with the discomfort and it can be okay. And I think that there are not examples of that, and so people just don't want to go there. They just don't want to do it because, you know, and so I think that we need to be honest about that. And actually, the more people feel like I'm an academic and I teach students and I'm a grown-up and I'm maybe a liberal, it makes people even more nervous about confronting the fact that they feel uncomfortable talking about race. And I think that it's that silence that's it's just killing us. The last thing I would say is that you have to be engaged with the community around you about race. And because that's the only way to have the real honest conversation. And to the extent that institutions are insulating themselves from that, I think that's a mistake. I shouldn't say lastly, because of course you have to deal with the issue of diversity. You just have to. You have to be willing to understand the way in which having the interaction of different views and ideas and perspectives and backgrounds only makes communication better, makes decision-making better, makes perspectives better. You have to respect it. It cannot be an add-on. It cannot be something that you do because it's something nice to do. I've been talking about this in the context of segregation, which is a speech I didn't give, but that I gave at the Derek Bell lecture earlier this year about segregation, which is, you know, an issue that if you invite me back, I would love to talk about, because I think that's actually the banner issue that we have to return to. And the problem with segregation, I'll just give you the small piece of it because I think it's helpful for your question, is that the whole project of desegregating, the whole project of integration, largely because of the way in which Brown was written, has been understood and described as something important to do for Black people, right? The doll test, that Black people's self-esteem, and all that. And we've never talked about the harm of segregation to white people. So I can send you the link to the lecture, but I think that we have to begin to see it that way. Diversity is not something nice you do for Black people. White people need it too. And so if we are going to be together in this thing, we have to stop treating equality, justice, diversity, desegregation, all of these things as like gifts we give to help Black people. Free stuff. It's not. It's actually essential work that we have to do for our democracy. And that means that in the context of the ecosystem of an institution of higher learning, you are doing it for the strength and the vitality of that institution and that ecosystem, not because it would be nice if we had a Black person come in and XYZ, right? So I think that's the That's what I'd say. You're welcome.
Last question.
Oh, yes. No pressure.
Good evening. My name is Chelsea Jackson. I'm an undergrad here at Emory. My question is more specific to you. Every time I see someone that's amazing, that's doing things I'm interested in, I want to dig into their backstory a little bit so I can get tips and tricks.
Oh, she got her book out and everything.
So my question is, it's sort of a two-part question. My first is, how and why did you decide to go into civil rights law specifically? And then the second one is, why for the NAACP? Why not a private firm or the DOJ, or you know, how did you sort of arrive at this point in your life?
So this is what I've always wanted to do. Lisa, what I say in college? You went to college with me. This was it. So I'm living the dream. This is, I mean, from the time I was a kid. My father was a very kind of political race man. We watched a lot of black and white documentaries on TV, and I loved it. And there was the period that I was growing up, when I was very young, there were a group of women in the 1970s who, you know, it was Barbara Jordan and Shirley Chisholm, and there were these women who were African-American women who were, I described them as, they were the first kind of famous non-decorative African-American women that I saw. You know, they weren't they weren't singing or anything, but they were incredibly powerful. And I kind of thought I was a little bit, even though I was a kid, and I thought that was a model for me of what I could do. But I wanted to do it. I was just saying this the other day, that, you know, when I would see these films with my father, I would feel, like, I remember it would make my stomach hurt, because I would feel like I missed it. Like I missed the thing that clearly I should have been a part of. And I told my children, it's the wonder of my life that now I am a part of it. But that's what I wanted. So I don't know how I came to that, but that's what I wanted. Why LDF? So the NAACP and the NAACP Legal Defense Fund are two entirely separate organizations. Just want to say that. Have been since 1957. We incorporated in 1940, celebrate our 75th anniversary. Why LDF? So when I left law school, I had a fellowship at the ACLU for the first year, and then a really great civil rights lawyer, Lonnie Guinier, was leaving the Legal Defense Fund, and she had been doing voting rights there, and they needed somebody to come and kind of just plug the hole for a minute. So I went to interview for this one-year position at LDF, and then I stayed for 5 years, and I loved it, and it's an incredibly, I can't describe to you. We did a reunion this year of LDF lawyers. First of all, you cannot believe the lawyers that were in the room. You just need to understand how many extraordinary people have been associated with this organization. And you know, you can be on the board of the symphony, and you can be involved with all kinds of organizations, but there are very few organizations that you can be a part of that literally change the country, literally. You know, I always say that I start counting democracy from 1954, because before that we had, you know, legal apartheid, so I don't really start counting it from then. So there is, you know, this room was affected by LDF. You know, almost every room that I'm in. You know, LDF won the first sex discrimination case in the United States Supreme Court. I think people don't even realize that. Like, you know, because there weren't women's rights legal organizations then. And when Ida Phillips, who was a white woman, came and had this case, she had an attorney at trial, and they asked us to help take it to the Supreme Court, and we did. She sued Martin Marietta. They wouldn't hire her because she had children who were younger than school age. And we won that case in 1971. Like, you know, death penalty, there is no part of kind of the pantheon that we haven't shaped. So it's an extraordinary privilege, and that's why I can believe that we'll win, because I know what the conditions were like. You know, I'm always reading Thurgood Marshall's letters, and it's extremely, you know, it's reading the letter from Robert Carter to Thurgood Marshall saying, I think if we raise, you know, $1,200, we might be able to do the Brown cases. Like, it's that, you know what I mean? And that was a struggle, like, to raise that money. But there was just a kind of a tenacity and a brilliance. And the last thing I will say is that I'm extremely proud of being the leader of, and when I worked at the Legal Defense Fund 25 years ago, being associated with a Black legacy organization that was created and known for its intellectual capacity. I just think that, so this is an organization of Black lawyers created in 1940, you know, and who are known as the best and the brightest. And, you know, I'm very proud of that. I'm quite unabashed and, I mean, you know, and unashamed to say that's who we are. Of course, we have a multiracial staff of lawyers and support staff, but that's our underpinning. And I think that's important for us as Black people to just to have that. I take very seriously stewarding that tradition, which is why the history is so important to me of what we were able to accomplish and what we still are able to accomplish. So that's the story.
Thank you.